One concept that's really important to understand about personal injury law is, I said at the very beginning, it's really like an amalgam. It's a collection of all these different laws. But what do I mean when I say laws? What specifically does that mean? Well, we have laws that are statutes, meaning the elected legislature in your state, the elected lawmakers get together and they pass a bill, the bill gets signed by the governor, and it becomes the law of the land. And that gets codified, meaning written down somewhere. It's a law that anybody can hop on the internet and Google and find it, and it's going to say you are not allowed to do blah blah blah. Right? It's going to have some prohibition or some rule. We call that statutory law. Okay. There's a whole other area of law, and this is law that most people never really think about, and it's basically judge-created law. Okay. The way that works is judges have to interpret those statutes. Or if you go back far enough in history, there were no statutes, and the judges were literally just looking at a situation and coming up with what they think is a good rule that should apply to everybody. But in the modern era, judges will look at the statutory law passed by the legislature, and they will interpret it when they try to apply it to a real-life scenario. Someone comes before them and says, hey, there's a law that says your neighbor's fence can't be more than 10 feet high within the city limits. And my neighbor's fence is 11 feet high. And because my neighbor's fence is 11 feet high, it blocks a little bit more of the sunlight when the sun is setting, and my grass is dying next to that fence. So I think that law allows me to sue them. So they broke the law, they had a fence that's too high, and I think I should be compensated because they broke that law and it caused me to have these losses. Well, a judge is gonna have to look at the law and say, well, hang on a second, the purpose of this law was just to allow the city government to write the guy a ticket if his fence is too tall. It doesn't say anything at all about using that as a basis for suing somebody. And so a judge is gonna look at that and they're gonna say yes or no, you can use it for that purpose or not. And here's where all the magic happens. That judge's decision is going to be binding on every judge that is further down the food chain from that judge. Every judge that is higher up the food chain or on the same level, because there's a hierarchy to the judiciary, which we'll cover in a second, every other judge who's above him or equal to him will choose whether they want to adopt that same rule. But everybody downstream has to adopt that same rule. Okay, so let's delve into that a little bit. In Texas, in my state where I practice, the low level of courts are called state district courts. Okay? In states like New York, and this very much so confuses the media or people that consume media, their lowest level of court is referred to as the Supreme Court. And so that's kind of perplexing because most people think of the Supreme Court as like the highest level, but it's just a coincidence of history that's how they choose to describe it. In my state, low-level courts are state district courts. Above that, we have the appeals courts, and then above that, we have the Texas Supreme Court. And I suppose in one sense, above that, for certain issues, we have the US Supreme Court, okay? If a Texas appellate court in Dallas says the interpretation of that statute is that you can sue the guy for having a fence that's too tall, then every district court within the geographic area, within that jurisdiction, they're gonna have to apply that rule. They don't get to choose. Their boss essentially told them they have to do it. But an appellate court in a different part of the state, they're peers with the Dallas appellate court, and so they get to decide, do I apply that rule or do I make up my own rule? When you end up with different courts at the same level that have different rules, then the mommy-daddy court, the Supreme Court, they get to come in and decide that split and say, no, we're gonna reevaluate, here's what the answer is. And then that answer flows downhill and is applicable to everybody, okay? So I'm gonna give you a real-life example. The type of lawsuit that my firm works on, and myself works on more than anything else, is what's called a dram shop lawsuit. It's a liquor liability lawsuit where you sue a bar because they broke the law and served a drunk person, and that drunk person then went out and caused an accident, okay? There was a Texas Supreme Court case that got handed down a year ago, and that Texas Supreme Court case changed a little bit everyone's understanding of what kind of evidence you need to prove that the bar overserved somebody, okay? Now, a lot of lawyers are very upset about that decision. I happen to think it was a good decision. I've used it to devastating effect against my opponents, and so I'm pretty happy with it. But a lot of lawyers, they look at it and they go, dang it, they just made it harder for us to win dram shop cases. They made it more difficult for us to prove the thing we have to prove. I disagree with that analysis, and I think I've demonstrated they're wrong, but nevertheless, that's kind of the general sentiment. Well, could a judge in San Antonio just decide, nah, I'm not going to apply that rule? No, they can't. They are bound by the Texas Supreme Court's decision, and so when a case comes before them concerning the topic of a bar being sued, they have to apply the rule that came from that decision. Okay? If an appellate court, so just one level up, in a completely different part of the state comes up with some novel new rule for liquor liability or dram shop, does that apply to a San Antonio district court? No, it can. They can choose to be persuaded by it, but they are not bound to follow it. Everything that we're talking about here is called precedent. And precedent is the thing that makes our system in America, which we again inherited from England, different from basically the rest of the world. Okay, and so let's delve into some of that just a little bit. In general, societies around the world are either have a common law legal system or they have a civil law legal system. That's not universally true. There's some places, Papua New Guinea may have something, totally different in tribal courts or something like that. I'm not getting into those kind of exceptions. I'm saying in, let's call it the West and places colonized by the West, there are either legal systems that more or less mirror what had been done in England throughout the medieval era, and then there are systems that more or less mirror the way that the French had done it. The French system is more in line with how the Romans used to do it, and that is you have written statutes for everything. A judge decides a case, and then no one cares what that judge says in the next case. Okay? In the English common law system, a judge decides something, and then that judge's decision is either binding on all subsequent judges if he's high enough up the food chain, or it's at least persuasive to all other judges. That judge's decision is recorded somewhere, and then people reference it, and that is law, right? That's what we're talking about here. So you have written statutes in our system, and you have case law, otherwise known as precedent, in our system, where a judge interprets a statute, makes up a rule where the legislature has never said anything about it, and then that stuff is to some degree or another either binding or persuasive on all other judges in the system. In the French way of doing things, it doesn't work that way. What the judges come up with in any given case applies only to that case, and it doesn't go any further. We could spend all day talking about which system is better, but there's one example that always jumps out in my mind as pretty darn good proof that the English system is better, that the common law system is better. And that is the African country of Botswana. Botswana, like many African countries, was colonized, and like many African countries, all of a sudden it wasn't colonized. The colonizers packed up and left. And almost all of the countries immediately around Botswana have very, very slow, poor performing economies, and Botswana is kind of like the exception to the rule. They have a pretty high functioning economy, particularly for that region. And there's a lot of reasons for that, but in my judgment, the number one reason is that they have the common law system of contracts. Now, where it's interesting is in other parts of their legal system, they actually follow the French model. They're a civil law society. But with respect to contracts, they adopted the English common law system. What good does that do for them? The English common law system is conducive to enterprise. It makes for predictable rules for business transactions, and near as I can tell, no one's ever come up with a better system. It's not perfect, but it's pretty dang effective, and more importantly, like I said, it's predictable. And so if you do business in Nigeria as a foreign investor, what is your recourse if something goes wrong? There's something, but how reliable is it? Whereas if I do business in Botswana, I basically know exactly what I'm going to get, right? Barring, whatever corruption or things that we can't really control. You have a predictable system, and that predictable system, in my judgment, is one of the key reasons why their economy is doing well, relatively speaking, compared to a lot of their nearest neighbors, which not only don't have a common law system, many of them are literal command economies, top-down controlled, like Marxist-style economies, and it's caused them tremendous problems in trying to expand and provide a higher standard of living for their citizens. So the point is, we have written law and we have case law, and both of those are important. I get calls from people all the time where they say, hey, I was in a car wreck. I don't know if I really need a lawyer. I looked up the rules, in the Texas Civil Practices and Remedies Code, and it seems pretty clear. I think I got this. And it's like, okay, well, what about X case? What about Y case? What about Z case? Do you know how that applies here? Oh, I don't even know what you're talking about. Well, there you go. I mean, you're not going to be able to make a demand if you're in a multi-car pileup without knowing how to invoke the case that says the first guy to file a viable demand, the insurance company has to settle with them, and it's not an excuse for the insurance carrier to sit back and say, well, we're going to wait and see what happens. If you don't know that that case exists and you file a demand without citing it, are you going to get any money? Probably not. So a lawyer has that knowledge. You as individuals don't need to go out and start reading 1,000 cases. It's not going to be practical for you, but just understand that that exists. The statute made by the legislature is part of the equation. The other part of the equation is the case law or the case precedent. And that is one of the things that really differentiates the system in America that we adopted from the English from basically the rest of the world. Okay. Okay. At the risk of beating this topic to death, I want to give you one more example of this kind of interplay between statutory law and case law. Okay, and so I'm going to make up a scenario here. I want you to imagine that your state has a rule that says you're not allowed to walk a dog in a public park after dark. It's forbidden. Okay. A couple years goes by after that law was passed, and somebody is walking through the park, and all of a sudden, another person's dog being walked through that park after dark in violation of the law comes up and bites them, draws blood, and that person now has an injury. They have to go get, incur medical bills. They have to get, stitches, rabies shots, the whole thing. Okay. Well, that individual sues under this law. They say, hey, you were in violation of that law. I'm going to sue you on that basis. Okay. It goes before the court. The court says, yeah, I mean, that was the intent that the lawmakers had when they passed that law. They want you to be able to sue people for this type of thing. And so we are going to allow that. Thunder forth. It goes to a jury trial. The victim wins. They get awarded compensation. That case decision is at the lowest level, but it's out there. Lawyers at least have heard of it, even if it's not front page news. Okay. Little time goes by. Someone's walking through a park in your state, it's after dark, and all of a sudden they get bitten by someone's pet hyena that they were walking through the park on a leash. Okay. The individual who's injured, they incur losses, they file a lawsuit, it goes before the court, but now the court has to consider something different. The law says you can't walk a dog through the park. A hyena is not a dog. So do we say, sorry, there is no law for hyenas that applies here? You're out of luck to the victim? Or do we instead say, well, isn't a hyena close enough that it falls within the intent that the legislature had when they passed that law? That's a tough question to answer. The judge is going to make a decision. Well, let's say that the judge makes a decision and they say, well, even though a hyena is not a dog, it has canine-like characteristics. And because it has canine-like characteristics, we're going to say that the law applies. The victim does get to sue. That decision at the trial court level gets appealed. It goes up to the appellate court, and the appellate court says, we agree. Now you have binding case law from an appellate court that goes to everybody downstream and everybody in their jurisdiction. So any trial court judge where that issue comes up, they don't even have to think about it. They've already been told by someone further up the chain of command, if a dog-like animal bites someone in a park, you can use that don't walk your dog in the park after dark rule against them, even if it's not really a dog. And so a couple years goes by, and the same thing happens with a coyote. They don't have to think about it. They've got a rule that says, yeah, treat it as a dog. Same thing happens, someone's walking their pet wolf. Don't even need to think about it. A wolf is clearly close enough to a dog. It's got those dog-like characteristics that the trial court's going to let that case move forward. A few more years goes by, and now all of a sudden, somebody is walking their pet cheetah. A little bit of a different story. Pet cheetah injures the person. They sue. It goes to the trial court. The trial court judge doesn't know what to do. He's stumped. And he thinks about it, and he goes, well, these prior cases say that they have to have dog-like characteristics. They stop short of saying it needs to be a dog, and in fact, they made exceptions for where it's not a dog, clearly, in the case of the hyena or the coyote or the wolf. So do we want to extend that further to a cheetah? And the judge says, no, I don't want to do that. I don't think it includes cheetahs. Plaintiff appeals, the injured person that is appeals, it goes up to the appellate court, and now the appellate court says, we do want to extend it that far. We think that a cheetah, even though it's a fundamentally different animal than a dog, it's got the claws, it's got the teeth, it's got 4 legs, it's got a tail. For all practical purposes, isn't it the same thing as a dog? And so the appellate court says if someone walks their cheetah in the park after dark, or any similar animal, as long as it has those characteristics, the teeth, the legs, the tail, the claws, then a victim can sue under that rule, okay? Well, now the rule makers at the state capitol, they're upset. They don't like that. They think that's gone too far. The court has completely screwed up the intent of this law. So they get together and they come up with a new law. And the new law is just a single sentence that adds to the old law that says it only applies to animals who are literal dogs. Now all that stuff that the court had done is eradicated and you start from scratch, okay? Well then, let's say people start cloning pets and someone gets a cloned dog, a dog made in a laboratory essentially, okay? And then they walk that dog through the park and it bites someone, okay? That is a dog, but the new rule says literal dogs. Well, what does literal dogs mean? Does a clone dog not literally, you see where I'm going with this. The court is there to continuously analyze this and apply it to real facts, a real injury, a real set of circumstances, and they make binding case law. And as long as the legislature stays silent about it, that case law controls things. When the legislature eventually gets aggravated with how far afield the court has gone, if that happens, then the legislature can pass a new law, right? That is the nature of where these laws come from that govern personal injury in American legal jurisdictions. Let's talk about a couple of subsections of personal injury law. It doesn't matter if you're talking about hobbies, if you're talking about construction, if you're talking about manufacturing products, specialization ends up becoming a thing, right? So if you've got your grandmother, she really loves jigsaw puzzles. I guarantee if you look into jigsaw puzzles, I've never done it before, I'm just guessing, but I guarantee if you look into it, what you're gonna find is that there are different camps or ideologies. Some people like the jigsaw puzzles with curved edges, and then there's gonna be people that only like them with angular pieces, and there's gonna be some people that really like it where it makes a recognized picture, and some people where it's abstract art or whatever. There's gonna be different subsections and categories within this world of puzzles. Well, personal injury law is no different, right? Within the world of personal injury law, not every lawyer is suing for all the different types of personal injury law. Some lawyers have specialized niches that they fulfill. And in fact, those lawyers are usually the ones that end up getting pretty good at that specific thing. Across the state of Texas, my firm is recognized for handling lawsuits against alcohol providers, and we do more of those cases than probably anyone in Texas. And so that is like a niche that we're known for. It's not the only thing that we do, but we've really kind of carved out a space for ourselves in that. And frankly, I think we understand that area of the law better than just about anybody out there. So within the personal injury world, you have these different subsets that arise where the rules can be a little bit different. And to illustrate that point, rather than reciting all the different areas, to illustrate that point, we're going to talk about one specific thing compared to another specific thing that you have definitely encountered to some degree or another before. We're going to talk about slip and falls and car wrecks, okay? Fundamentally, they're kind of the same. They're both negligence claims. You're basically saying the property owner was careless in some way, they didn't behave as a reasonably prudent person would, and therefore I'm suing them because they caused my injury. And the same thing, all those same words, only just swap in the word motorist or driver, okay? Well, in the context of a premises liability case, a slip and fall case, for example, you have a different kind of competing interests. And you have competing interests that are older, a lot older than what you have with respect to automobiles, okay? In the early days of the automobile, a lot of lawmakers came down and made very, very harsh laws that basically made the driver of the car responsible almost irrespective of the circumstances. I'm exaggerating a little bit, but they imposed very major penalties on the driver of the car. And if a pedestrian jumped right out in front of the car, it may not even matter in one of those cases. It may ultimately end up being the driver of the car's fault just because. Well, that's because, at one point in time, cars would be like your neighbor owning a rocket launcher, right? It's not typical. It's not something that's normal. And so they kind of considered it to be extraordinarily dangerous. Well, now cars are everywhere. They're ubiquitous. It's an inherent part of how our society functions in this country. And so there's now more of a balancing of interests, where they're going to look at, okay, the driver of the car did something wrong, but what did the other guy do? What did the pedestrian do? Did he contribute to this incident? Did he cause it in some way? And you end up with kind of this balance of interests that probably sounds pretty familiar to you and feels pretty intuitive, where it's not just, hey, the driver of the car is always to blame. We're going to ask how the thing unfolded, and we're going to explore it in detail. Well, something similar happened with respect to property ownership. And that is, without getting lost in the philosophical or political sauce, property ownership is something that has essentially always been protected by the law, okay? And in many cases, it was the first type of legal protection that emerged in a society. Well, property ownership, as protected as it is, we still also want to help the regular guy who gets injured on someone's property. And what has come out of this is this amazing, swinging of the pendulum over generations, where we have rules that say you can sue the property owner, and then all these different complex legal requirements that protect the property owner. So I'm going to use the Texas rules as an example, just to show you, not to make you an expert on Texas slip and fall cases, but just to show you kind of how within this niche you can have developed all these hyper-specific rules that don't apply to car wrecks or whatever else. Okay, imagine this scenario. I go to your house. I am there as a dinner guest, okay? You invite me into your house. You have a loose floorboard. I step on it. My foot goes down into the basement. The thing comes up like a seesaw, like in the old cartoons, and it injures me, okay? Can I sue you for that? Well, here's how the analysis works. The first question the court needs to ask is, what type of visitor am I? There's three kinds of visitors. There are trespassers, there are licensees, and there are invitees. Now you might think, okay, well, he's not a trespasser, right? Pretty easy. But isn't he an invitee? He was invited to the dinner party. And the answer is no. The courts have told us that when you go to someone's house for a social call, you're a licensee. What in the world is the difference? The property owner has to protect a licensee only from hidden hazards. It has to protect an invitee from any hazard that they could fix but haven't gotten around to fixing yet, whether it's hidden or otherwise. Okay, I'm way simplifying it, but that's essentially a distinction. So if I go to your house and suffer that injury, did I know the floorboard was like that? No. Did you have a sign warning me? No. It's a hidden hazard, therefore you should have protected me. And in that specific way, you're negligent, I can sue you, I'm going to end up getting money from you because of that injury, okay? If the exact same scenario had happened, only we're in the kitchen and the dining room having this dinner party, and then I decide I'm going to help myself into your bedroom. I just wander in there because I want to go snoop around, or I want to use the bathroom in the master suite or whatever. Now, even though you invited me to your property, I'm technically a trespasser. I went somewhere you didn't give me permission to go to. And if the same exact injury happens there, can I sue you? The answer is probably not. Because as a trespasser, the only duty that you owe to me is to not harm me through grossly negligent conduct. Okay, so if you put a booby trap in there, okay, that's gross negligence. I'm probably still going to be able to sue you. But if you have a rickety floor that could very seriously injure me, but you keep me from that area, you don't allow me to go into that area, then you don't have to protect me from that. You can be negligent in that fashion, and I've got no recourse against you. There's always exceptions. If you implicitly state that I can go to to that area of the house, even if you don't explicitly state it, in other words, if it's like, hey guys, any door that's not locked in this house, you're welcome to, and the bedroom door is not locked, okay, well then I'm no longer a trespasser. I'm back to being a licensee, okay? With respect to the invitee scenario, that generally only applies when you go to a place for the benefit of the owner, such as if you go to a retail establishment. So if you go to Walmart, you're there according to the court, for Walmart's benefit to engage in some sort of commercial transaction. Walmart has to be hyper vigilant. They've got to seek out all of the hazards that they reasonably can find before you get to them and injure yourself. Okay, so if a customer comes into the store and the customer spills some milk on the floor in Walmart and it sits there for 6 or 7 hours, and then you walk into the store and slip on it and hurt yourself, Walmart had plenty of time to find that out, and therefore they had a legal duty to protect you from that hazard before you ever got there. Okay, or let's say a Walmart employee himself spills it and it's only there for 10 minutes, but he just decides, I'm not going to clean it up. They definitely had notice of that. They knew that they should fix the hazard and they didn't. And so you would say that Walmart is liable. Most juries are going to agree with that. Okay. But if you have a scenario where a customer spills it and only 10 minutes passes, it's really debatable as to whether the jury is going to find in favor of the injured person or in favor of Walmart. Right. So the point I'm making in all this is that there are all these super complex, intricate rules related to this one area, slip and falls, that have nothing at all to do with the rules in car accidents, medical malpractice, lawsuits against alcohol providers, lawsuits against daycares, et cetera, right? And then there are areas within personal injury law that are so far afield that they're almost utterly foreign to all of the stuff we've been discussing. Two examples would be workers' compensation and maritime law, okay? Why are those so weird? Because those are entirely statutory. Legislatures have gotten together, they've created a set of laws that apply to work injuries or to accidents that happen on the high seas, and they are fundamentally different than what we deal with in a negligence case or even an intentional act where you're suing someone for hitting you or assaulting you or whatever. So the point is, you have specialization, you have all of these little niches, and what the general public, I think, has been very uninformed about with respect to that is that you can have a scenario where something seems completely unfair. I'll give you an example. There was a guy on a Carnival cruise ship that got smacked in the head by an automatic door, and he was awarded something like $20 million. And there was a lot of public outcry. People were like, oh, that's outrageous. The guy didn't die. $20 million is too much money and all that kind of thing. Well, part of that is we don't know how badly that guy was hurt. The jury does. He may be debilitated for the rest of his life, and the jury felt that was worth $20 million. But the easier point to make, the more important point to make, is it doesn't matter. We can't take a scenario that's familiar to us, like a slip and fall or a car accident or whatever that everyone in the public is familiar with, and then assume that the same rules apply in the maritime case. In the maritime case, there is a fundamentally different standard of proof. There's a fundamentally different thing that makes the bad guy responsible. There's a fundamentally different type of compensation that's available. And so it is an apples and oranges comparison. The reason I go through all this detail and tell you this is just so you understand when you hear about something in the news and you're evaluating a jury's decision, you got to keep in mind that unless you know which one of these highly nuanced, specific set of rules applies, it's basically guesswork, and you probably shouldn't take commentary on it too seriously without having that understanding. Next, we're going to talk about kind of the two big parts of a personal injury case. Okay, we mentioned earlier how every different type of cause of action has elements like duty, breach, causation, damages, that kind of thing. The way that the case is put on in trial, there's usually two big areas or spheres, or however you want to describe it, of the case. One is liability, the other is damages. Okay, so you can have a defendant that checks all the boxes, they broke all the rules, they did the horrible thing, but there was no economic loss, no injury that was incurred by the supposed victim. And so there you'd have a really strong liability case, but you've got no damages. That case isn't going to work. That's not going to fly. Okay. What if you have a case where you have astronomical damages, but nobody did anything wrong? Well, then that case isn't going to fly, or at least it shouldn't, right? So if you've got a scenario where, someone's walking through, their own house and they trip over their own shoelaces and they fall and they suffer paralysis, horrible, debilitating illness where they're going to require millions of dollars of care for the rest of their life. You've got huge damages, but who's liable for that? The individual himself. He can't sue himself. That's not going to work, right? So the takeaway from this is that any personal injury case, in order to be viable, is going to have both liability and damages. You got to have both of those things in order for the case to be practical to take to court and to win. But there's actually a third thing that has nothing to do with the court, everything to do with common sense that you have to have as well. That is, you've got to have a viable defendant, okay, a financially solvent defendant. Think about that for a second. You're riding your bicycle, out of nowhere comes a guy in a soapbox derby car that he built in his backyard. Okay, he's coming down the hill and he runs you over. You're very badly injured. Okay, do you have liability? Yeah, he's negligent. He has a duty not to hurt you. He breached that duty. The breach caused you to have losses and damages. You've got a negligence case against him. Liability is good. You've got damages. He broke both your legs. You've got $100,000 in medical bills. But do you have a financially solvent defendant? Turns out the guy was living with his cousin. He doesn't have a job. He doesn't own anything other than the clothes on his back. And he found a bunch of scrap lying around and decided to build this rickety little soapbox derby car, and he ran into you. As a practical matter, you could have the best lawyer, put on the best case, get the best jury, and the jury could award $11 trillion bajillion dollars. And you're never going to see a penny of it because the guy doesn't have any insurance or any assets. So as a practical matter, there's really three parts to a personal injury case that you need. As a legal matter, there's two parts. You got to have a showing of liability, you have to have a showing of damages, and you need evidence to support that. But as a practical matter, if you get injured by a homeless person, you don't have a viable case. You can't do anything with that as a practical matter. And so you really need to think of it like a tripod. It's got three legs. If you take one of those legs away, it falls over. It's not going to stand on its own. Your personal injury case works exactly the same way. Lastly, let's talk about, at a very high level, rules of procedure and rules of evidence. Okay, so we've spent a lot of time talking about where the law comes from, what kind of things you need to prove to win a case, all that kind of thing. Let's talk about how you do it. Every state has something called rules of procedure, and this is no different than like rules of a board game or rules of a sporting event or something like that. It's not a free-for-all. I can't, as a lawyer, get hired and start rummaging through some guy's trash in most cases. I can't, call up the guy that I'm suing and say, hey, forget about your lawyer. I want to talk to you directly. There are rules in place to keep that kind of stuff from happening, and we call those rules of civil procedure. The rules of civil procedure cover a broad variety of things, but the takeaway here, what you have to understand, is that they specifically dictate how you're able to put on the trial, okay? So if I go into court and I put my own witness on the stand, my own client, and I start asking questions like, you're really nervous about being here, aren't you? You didn't do anything wrong, did you? Well, those are what we call leading questions. It's a question where I'm kind of giving them the answer that I want to hear back. And the rules of civil procedure say that a lawyer can't ask his own client leading questions unless it's to clarify unclear testimony and various other exceptions like that. I can use those kinds of questions on the other guy's witness. So if I call the wrongdoer himself up to the stand, or his coworkers or something like that, and I ask them leading questions, that is something that I can do. I said it a little incorrectly. If they were called up to the stand by their lawyer, he asked them direct questions, and then when it's my turn on cross, I can ask leading questions, okay? All of that stuff, all that minutia comes from the rules of procedure, and it's designed to make things fair. That's really its whole purpose. Then there's also the rules of evidence. Let me give you a specific example. I was in a court in San Antonio a couple weeks ago and arguing that a piece of evidence that my opponent was trying to use was not admissible. This piece of evidence was a certificate showing that an employee of a bar had gone through special training, and because of this special training gets special treatment under the law. The defendant in the case, my opponent, they went into the employee's file, they grabbed this sheet of paper, they have no idea where it came from, the employee gave it to them, they stuck it in the file, and they took that sheet of paper and then wrote out something called an affidavit, which is kind of like you're testifying in writing. And they said, I, such and so, am the person that handles HR for this company. I looked in this employee's file, and that's where I found this thing. So you know that this thing is legit because I found it in the employee's file. And then they were trying to use it as evidence to prove something in court. And I said, not so fast. The custodian of records for the defendant, so their HR person who handles employee records, the only thing they can truthfully attest to is that they found it in the employee's file. They're not the ones that created the document. They can't testify that it is a legitimate document. And turned out it was a document from a state agency. And so the only entity that could say that it was real was the state agency itself. And so I objected on that basis. I explained to the court, this is inadmissible hearsay evidence. They're claiming that something that someone outside of this proceeding has said is true, and we don't allow that under the rules of evidence in the state of Texas. What they should have done was gone to the state agency, gotten something from them in writing saying, we, the state agency, hereby attest to the fact that this is a true and complete record showing blah, blah, blah. Okay. Then if they bring that into court, it's proved up. I don't have anything to say about it. But they didn't. They instead looked in the employee's file, got this mystery document that the employee got from who knows where. They could have photoshopped it. And then they tried to use the HR person to say, yep, that document's legitimate. Sorry, it doesn't work that way. Well, how do I know this? It's because in addition to the rules of civil procedure, we also have rules of evidence. Rules of evidence are detailed and kind of dull, and so the general public usually doesn't know anything about it, and maybe I'll make a video in the future discussing those rules of evidence in detail, but here I don't intend to do so. I don't want to get lost in the sauce on that. What I want to demonstrate is that to understand personal injury law and how it applies in court, you have to have an awareness of the fact that these rules of procedure dictate how the trial works, and these rules of evidence dictate what the jury gets to hear about. You can have the best stinking evidence on the planet. It absolutely proves your case. And if you have not gone through the proper steps to get that evidence proved up, made admissible into court, the jury never sees it. My parting thoughts are going to stem from that. And that is that, you've heard me mention periodically throughout this video that people have misconceptions about the law, that they hear about cases in the news and they kind of react to it without fully understanding it. And I think that there's no greater example of that than misunderstanding the rules of evidence. Armchair quarterbacks who are not lawyers, who are not well-versed in the court and in the functions of the court, they will hear about some outcome. Some guy got his leg chopped off and the jury gave him $5,000. Oh my gosh, that's unfair. Or some guy broke his pinky and the jury gave him $5 trillion. Oh my gosh, that's unfair. And what we on the outside have no idea about is what evidence the jury got to see, right? That's not something that the public is usually told about when the news covers it, because frankly, the news barely understands how the legal system works. They report on it as if they do, and they get it wrong most of the time. What you end up with is a scenario where if you don't know what evidence was presented to that jury, if you don't know what the rules of procedure said that the judge was allowed to tell the jury in their instructions when they were reviewing the evidence, if you don't know how the witnesses appeared to the jury, whether they were credible or not, then how can you sit there and second guess what the jury has done? Because you don't have the crucial information that you would need to find out if that's a proper evaluation. Now, to some degree, we're talking about pondering the imponderables. We're talking about discussing things that are so subtle that it's hard to say that there really is a universal right answer or wrong answer, or right analysis or wrong analysis. But as a threshold, before you jump on the bandwagon and decide, oh my gosh, the system's broken, how could this outcome occur? You got to at least consider the possibility that there's some big piece of the puzzle that the news didn't tell you about and that you were not privy to. I wish I could tell you that every time I step into a courtroom, everything goes exactly my way. And knock on wood, I've never had any major losses. But I have had little minor ones that come up where I ask for the court for a little more than what the court's willing to give me. I go in and say, hey, judge, these guys tampered with evidence. I want you to go ahead and decide this case right now in my favor because of their misconduct, and don't even let it get to the jury. Well, as you can imagine, judges aren't super willing to give me that, but it's one of those things, if you don't ask, you're never going to find out. And so as a lawyer, I may advance positions with the hope that I get what I want and with a good faith belief that I can get it, that I've met the legal requirements. But you don't always get it because judges tend to be a lot more fair than that. They don't usually want to come down on one side, so harshly that it prejudices them in some way. And so I've certainly had scenarios where I didn't get what I want in court. But the one thing that I have never done is whine about it. If I don't get what I want in court, I don't sit around and go, oh my gosh, the whole system needs to be scrapped, pull it out root and branch, throw it in the trash. We need to start over. We need to fundamentally remake society. And so my parting thought is this. Before you are persuaded by people that tell you that we need to do that to our civil justice system, I want you to ask them, have you at least taken the time to watch this stupid video by this lawyer out of Texas where he tries to explain how this stuff works and how we should at least consider what evidence the jury saw and what rules were in effect? Knowing that you need to ask the question before jumping to the conclusion is one of the major breakthroughs that most people make when they get from being just sort of a reactive person to someone that's capable of, that higher level of analysis. And I would encourage anyone that had the patience to sit through this boring nonsense to hold themselves to that standard and to say, before I decide that I'm going to evaluate and second guess what a judge or a jury did, have I really taken the time to look at this case, understand the legal issues, understand the rules that apply, and do I have any understanding of the evidence that was presented? And if the answer to any of those questions is no, partner, you probably need to settle down a little bit, go back, look at those sources, and then decide how you want to evaluate the case. When you're able to do that, then you really have reached that next level of understanding not just personal injury law, but understanding the law in general.